Hello landlords, it's Ernie. Today we're talking all about what's commonly known as the Pauper's Affidavit, or the Affidavit of Inability to Pay. Let's get started. Every week I bring new content for you to learn from. If you are interested in learning even more about landlord-tenant law, don't hesitate to hit the subscribe button. If you like and comment, I do my best to read and respond to each of the comments that are presented below. So you may have a question about a topic or a question on a topic that you'd like answered. Don't hesitate to leave that comment below and I'll do my best to get a response to you as quickly as possible. So today we are talking about that dreaded Pauper's Appeal. This happens generally in the justice court after an eviction has been lost. The tenant will file an affidavit of inability to pay costs, which is widely known as the Pauper's Affidavit. And many landlords are confused as to why this is even an option, and they want to challenge these affidavits on top of, just telling the court how wrong it is for the tenant to be appealing at all. And so I'd like to talk about some of the pitfalls in addressing the Pauper's Affidavit and challenging it in ways that are available, and instead give you some advice about how to operate the Pauper's Affidavit in a way that works best for you as a landlord. So number one, should you be surprised that your tenant appeals by Pauper's Affidavit? No. The vast majority of tenant appeals are by Pauper's Affidavit. Because it's very easy and it's not subject to very much scrutiny at all. The affidavit is available to anyone. You sign it and submit it. Now, it is typically not available for a commercial tenant. So if you have a commercial tenant who is trying to use a Pauper's Affidavit, that affidavit you may want to challenge, because typically a business cannot be a pauper. This is essentially relegated to individuals and for purposes of individual household use, not for companies. So if your tenant has filed an appeal by way of a Pauper's Affidavit, essentially what they're saying is, I cannot afford costs, but they are also obligating themselves to pay rent into the court's registry month to month as it comes due. In fact, the first payment of rent that they're to make into the registry should be made within 5 days after they have filed their appeal by Pauper's Affidavit. So this is technically good news for you on two fronts. Number one, if they pay this amount, there's at least something for you to collect at the end of the case, should you be successful on the county court level and there's no appeal beyond that. The funds that were paid into the registry belong to you, and based on your success, ultimately securing a judgment on the county court level, you will be awarded, or can be awarded, these funds that are in the registry. But there is another good reason why you want this affidavit in place and you want all the obligations in place. Because what happens if the tenant fails to make that payment within the 5 days as required by the rule? Well, that failure automatically entitles you to a writ of possession. However, most landlords who find themselves in these positions just don't know that the rule says that. And if they do, they don't know how specifically to exercise that rule in a way that makes sense for them. Instead, what ends up happening is the tenant files for an appeal by affidavit of inability to pay. They never make a payment. The matter pushes forward on to appeal. Believe it or not, even when the tenant fails to comply with their own Pauper's Affidavit, the appeal is still valid. The appeal is valid upon the filing of the affidavit, not upon complying with the rules associated with it. So the matter goes on appeal. They've made no payment. You get a trial setting at the county court level. Maybe they don't even show up to the appeal. You win on appeal, but you're able to collect nothing from the court's registry. Well, there are two mistakes that are commonly made by landlords in this situation. The first is to not know the deadline when the money is due in the justice court. If the tenant appeals by this affidavit and has a set deadline, and they always do, they must pay a set amount of money into the court's registry in order to maintain possession. And they have a very specific deadline for it. If they miss that deadline, you are entitled to an immediate writ of possession. But most landlords don't know this. The failure to pay is your best bet that you'll recover your property. The eviction appeal will continue on to the county court, but you can recover possession. If you didn't know that, well, now you know. But there's another rule that even landlords who know this rule sometimes get wrong. And that has to do with the window in which they must request their writ of possession. It's usually just 1 day. And so let's say a tenant is required by Tuesday afternoon, 5 o'clock, to pay their rent into the court's registry. And if not, Wednesday morning, you are, as a landlord, allowed to get a writ of possession. Again, that eviction appeal will go on to the county court, but their failure to pay by 5 o'clock on Tuesday should allow you to go into the court on Wednesday and purchase a writ of possession. Once you purchase that writ of possession, it takes about 1 to 3 weeks for the county to carry it out, but that's much faster than you would get if you waited for the trial on the appeal level. However, if you miss that window, and usually it's just the 1 day, if you miss the opportunity to purchase the writ of possession after the tenant has failed, the case moves downtown and the justice court will not assist you. Once that window closes with the justice court, they don't even have the power to issue a writ of possession. You would have to get it from the county court. To get one from the county court, you'd have to set a motion and a hearing and schedule it on the docket. And the truth is, many times it's difficult to get these hearings on the docket before the trial setting. And so you have a moot point because the court's not going to issue, generally speaking, an immediate writ of possession on the same day when they're hearing the issue for trial. Possession will likely go the way it normally goes through the judgment with a 10-day waiting period. So if your tenant is scheduled to make a payment into the court's registry, know the deadline, find out if they've missed that deadline, and act immediately. The very, very next morning, be at the courthouse prepared to secure your writ of possession. This puts you in the best position to recover your property faster without having to wait for the delay of the county court appeal trial. Now, again, once the case shifts to the county court, you still have remedies there, because while the tenant has appealed, that appeal may cover 6-7 weeks, and that may cover additional rental periods. And the agreement that they sign and what the rule requires is that while the matter remains on appeal, they are to continue making their payments into the court's registry each month as rent comes due. So in our first example, a tenant has rent due on Tuesday. Technically, as the rule goes, that's for the current month and their ability to reside on the premises in the current month. So it doesn't matter what day of the month that is, it's for that month. They are to pay another month's rental the next month when rent comes due. Generally speaking, that's the first of the month. And so let's say the first deadline is Tuesday the 20th. And the following month, on the 1st, rent is due. And so it doesn't matter that they paid rent fewer than 30 days in the past. The following rent period, on the 1st of the month that comes up, they owe a payment into the court's registry on the county court level, which means they'll likely owe that payment into the county clerk's office. The majority of tenants who do make the first payment do not make the second payment. They just don't know how to do it. And so you get an option at this level to attempt to set a hearing. And there's a good reason to request this hearing. There's 2 good reasons for it. Number one, it could motivate your tenant to make another payment of rent into the court's registry so that they are allowed to stay. But if there is enough time to get a hearing between that default and trial, you could potentially get an immediate writ of possession and recover your property sooner rather than later, waiting for the eviction trial. Everything that we're trying to show you here are ways that you can use the Pauper's Affidavit in your favor. There are rules that are set up to protect you as the landlord, but if you don't know these rules or how to operate within these rules, you're going to be left for the court to simply do its job, which is to hear the eviction appeal and issue a judgment thereafter. But if you know how these rules operate, you know how to use them in your favor to get results quicker. Now, next I'm going to tell you about something you should not do, which is 99% of the time I'm going to counsel landlords against challenging the Pauper's Affidavit. And here's why. I've told you some of the goodies that you have in terms of the potential for rent payments into the registry, securing your judgment, in terms of the potential for recovering possession of the premises even sooner if the tenant defaults with regard to those payments. But challenging the Pauper's Affidavit turns out to be a huge waste of time. Typically, what happens is an Affidavit of Inability to Pay is filed with the Justice Court, and a landlord is livid. And they're like, no, this is not happening. I'm going to challenge it. And so all that happens is the matter is delayed. A hearing has to be set in the Justice Court so that the challenge can be heard. And if the docket is already pretty booked, it may be a while, I mean, a week or two before you get an actual hearing, but you're entitled to it. The matter is heard even if the court agrees with you and denies the Pauper's Affidavit. The tenant has the right to appeal that ruling. Now, this isn't the overall appeal. This is an appeal of that specific ruling. That ruling then goes to the county court at law, gets its own docket number and court, gets set for a hearing, and gets decided. Now, I just want to make sure that it's clear. This is not your eviction appeal. This is a ruling contesting the challenge for someone to use a Pauper's Affidavit. So 3 or 4 weeks later, you'll get a hearing, and the county court judge will say, so the Justice Court judge said no Pauper's Affidavit. I think I'm going to go yes with the Pauper's Affidavit. So then that matter goes back to the Justice Court. You've spent a month and gotten nowhere. Let's say it doesn't go in your favor. Or let's say the county court says, I agree, no Pauper's Affidavit. Well, all they're going to do is in this time, they've probably either heard it from the court clerk on either level or done a little bit of research and found they don't have to pay a cash bond. And usually that's what they're trying to avoid. They can pay, they can simply fill out what's called a surety bond. They find some third party, and that third party says, yeah, I can secure this judgment, and it's the same rules as the Pauper's Affidavit, right? You might have one other person who's involved in the judgment now, and they might have to pay an extra fee, but that actually makes it worse, because if they file with a surety bond and they are required to pay the filing fee, once the matter goes back to the county clerk's going to give them 20 days to make that payment, and you better believe they're going to wait out those full 20 days. The other issue is if, for example, you contest the Pauper's Affidavit after all of this and you're successful, and instead of a surety bond, they pay a cash bond. They may end up paying sometimes 3 times the monthly rent. Depending on the court. There's all sorts of ways that courts do this, and I've seen some courts that will not issue more than a $500 cash bond. Now, if I were representing the tenant, I'd say pay that. That's the least amount of money you'll have to pay, and you get, the landlord has to wait until the matter goes to trial. So there are some configurations where you don't want the tenant to pay a cash bond. If they've been told, okay, you're going to pay 2 times the monthly rent, but the entire process takes 4 months, you've lost out on 4 payments into the court's registry that you otherwise could have had, or that could have prompted a default and a ruling for an immediate writ of possession. Sometimes it just isn't worth it to try to force the tenant to pay a cash bond let them stay with the Pauper's affidavit. Again, they have some stiff penalties if they fail to comply. You have access to money into the court's registry, assuming that they do comply. There are goodies in there even for the landlord, so long as the tenant pays into the registry, and if they don't, you get your writ of possession. But you have to know the deadlines, and you have to understand how they work. The best way to get this understanding is once the tenant appeals by affidavit of inability to pay, and here's a copy of what it looks like. Once they've made that appeal, contact the court immediately and ask what are the deadlines, how much is owed, and on what date must it be paid. Then, if you have not been notified by them, call the court the following day. So if you know, again, Tuesday is the deadline, Wednesday morning, first thing, call the court. Did the tenant pay and meet the deadline? If the answer is no, your next question is, can I get my writ of possession today? The answer to that should be yes. Rush to the courthouse, purchase your writ of possession, and begin the process to remove the tenant. If the answer is yes, they did meet the deadline, they did make the payment, then your next step is to follow the matter to the county court level. Once the matter is there, contact the county clerk, particularly on the second day of the month when rent is next due, and check to see, was a payment made by the defendant into the county clerk's office in accordance with the rule to make payments into the court each month as the rent comes due. If there was no payment, you'll want to file a motion for an immediate writ for default of that rule. Get that matter set before the court in advance of the appeal trial, and you might be eligible for an immediate writ of possession to recover your property sooner than you could otherwise do it through the eviction appeal. I know I've covered a lot. There's a lot of information that goes into an appeal and the rules that are required to navigate it well. If this is something you are interested in learning more about, I've got other videos that have to do with eviction appeals and the Pauper's affidavit. My contact information is below. If you are interested in reaching out to us, don't hesitate to send us an email. Don't hesitate to send us a text or give us a call. If you're interested in a one-on-one consultation with me to discuss your eviction appeal and the route that your case is headed and what you might do to better position yourself, reach out to us and book a consultation. That's the best way to get this done. In fact, here recently I was talking to a client and he called on he called the day his writ of possession was available, and I told him, look, you can get a writ of possession today, and today is the last day to get it. We called the court together, confirmed that. We're told if you don't get it tonight, tomorrow morning when the clerk comes in, she's going to process everything. So you cannot even do it tomorrow. And he said, well, what if we're there at 8 in the morning? He says, well, she gets in early, and she's going to send everything out before 8 o'clock, and so there's no availability for you. Fortunately, we were able to purchase that writ of possession. We requested it via e-file the afternoon, which was, again, the absolute last day to get it. And now this client's going to be able to secure possession of their property. He did not know this rule. We shared it with him. We worked fast, and we will get possession for this client, again, much sooner than he could have, waiting out. His goal was, I want to know how to win the eviction appeal. I told him, I've got something better for you. Get your writ of possession today. That's what we did, and I hope he's a happy landlord because of it. Again, if you have questions, reach out to us. I will come back with more videos having to do with appeals and how to navigate the world of an eviction appeal. But until next time, happy leasing.